So, let me now turn to the bottom, the number 4. What can you do? What I have found in talking to groups is that many groups are unaware of an incredibly powerful tool, and that is the Chapter 13 in Minnesota, the Data Disclosure Act. Under Chapter 13, there is a presumption that you own every piece of paper in state government, and if you want it, you can get a copy of it. And you can get a copy 2 ways. You can send a letter saying, please send me copies of all your documents that meet these requirements. Or alternatively, you can go to City Hall, you can go down to a government agency, and you can tell them, I'm going to be there on May 27th. Please lay out all your documents that deal with this subject, and I want to review them, and I want somebody there who, when I want a copy, I can hand the person a copy. And this is relatively inexpensive. It's $10 a copy. There may be some fees for administrative costs, but these are your documents. You, as a taxpayer, you have paid for them, and it is a great way to supplement your advocacy with some more details of, in fact, what is going on at the city agency, at City Hall, at the state agency. So what I've included here are 2 letters that I've written to get documents, and you may plagiarize those letters whenever you need it. And if you really want, send me an email, and I will send you the Word document, and you can copy it right over in Word. Dennis.
I can understand that in the interest of time, you have abbreviated from your outline. I don't know how many people are interested in, but I have been meeting with the Minnesota GOP Judicial Chairs Committee for a number of months regarding legislation to reform justice in Minnesota. I'm curious to find out, to have you take a look at number 3 on your outline.
Oh, sure. One of the horrible things about the Roe v. Wade decision was that it constitutionalized an issue that, in my opinion, should be left up to legislators. It took the issue of abortion out of the legislature and put it beyond the reach. And the reaction to that was, we don't want judges to ever do anything like that again. And so conservatives post-Roe reacted, in some respects, quite rationally, that this was such a horrible decision. We don't want judges to ever do anything like that again, or it's judicial activism. In the 1930s, liberals and progressives, when it came to economic regulations, particularly the work of the New Deal, we're tired of the court overturning New Deal programs. And when it comes to economic regulations, we don't want the court, liberals say, to judge. And so you have liberals saying, we don't want the court to judge on economic regulations, and you have conservatives saying, we don't want the courts to judge when it comes to certain social, taking them off the table, social issues. And so now all of a sudden, judges are, I think, aren't doing their jobs. And I think the progressives have gotten it wrong in terms of locking the door to judges judging on economic regulations. And I think lots of conservatives have gotten it wrong, that they just want to put judges completely out of business because of what I believe was the wrong decision in Roe v. Wade. Just stop them from ever judging again. And so you have this cacophony from both sides saying judges don't judge. Now, when it comes to economic, so we advocate an alternative. We advocate a judicial engagement. We think judges should judge. We think judges should strike down excesses in democracies that violate the constitutional limits. So put this next to our discussion about hair braiders. We won the case in hair braiding because the facts were just so absurd that you have to spend $15,000 and get 0 hours of training. Let's make the facts a little bit more, a little less compelling. The city of New Brighton wants to license tree trimmers. Well, we've just had a hurricane. There's a little bit of fraud that exists. Should the city of New Brighton, like the city of Minneapolis, license tree trimming? People hurt themselves. Should they do that? Well, I think there's a compelling argument that they should not license tree trimmers. But what has happened is, and the tree trimming industry is going around knocking on City Hall doors saying, please license tree trimmers. And no one in opposition to the tree trimming shows up at City Hall. So we have this problem of concentrated benefits, and then and dispersed costs, and then we have the fact that the progressives have locked the door. So beyond the hair braider, the next person who challenges a crazy occupational licensing case finds that judges, built on the tradition of the New Deal, really don't want to hear the case. Even when democracy is so distorted by the fact that the consumer who's paying the bill doesn't show up at City Hall or at the state capitol. So we think the New Deal jurisprudence is wrong, and judges should be engaged in stopping the excesses and dealing with the problems of concentrated benefits and dispersed costs. Yes?
Don't you think a lot of times it's stereotypical nowadays that people are hearing a broader scope of what judges are, and they're thinking they're interpreting their own way of what the law should be?
Yes.
And I think that's where a lot of people are down on judges, in the sense of you just hear too many cases that they're just interpreting the law for their personal beliefs and not.
Yes, Gina, I think that's very insightful. The whole living constitutional movement, I think, is bankrupt and illegitimate. The idea that this document, this piece of paper, goes through life and it changes, is an invitation for a judge to have that document change in the way that reflects the judge's political views. I think the Constitution is robust. I think it is applicable to today's issues. I think it protects a lot of liberty. It doesn't have to be living to do all those things. It can be a magnificent 18th century document and still protect 21st century liberties. I think the whole idea of an empty vessel that you can pour your preferences into, and by golly, the Constitution goes back and says, "You're right, Your Honor." That's the problem. And that, in part, is the reticence of conservatives to engage, give judges more leeway, because they see on the progressive side this vehicle that progressives have created that allows them to find certain rights that aren't based on the 18th century.